Hello and welcome to today's podcast. I am delighted to be joined today by Melanie Bataillard. I can't even say it. Honestly, I knew this was going to happen. Right, I'm going to let you introduce yourself, Melanie, because I failed miserably, having been told how to pronounce your name 2 minutes ago, already failed.
Don't worry, Tamsin, it's not an easy name. So the name is Bataillard Samuel. It's Melanie Bataillard Samuel. And I am a family law solicitor, but I specialize in international family law, and most of my work is European based, so primarily the French market, but also all over Europe.
Fantastic. And that is why we have asked Melanie to join us today, because we're going to talk about international divorces. So because that is the area she specializes in. Melanie's also on the National Committee for Resolution as well. Is it just the National Committee these days, or are you still on half a dozen others?
I'm on the National Committee. I'm co-chair of the Innovation Group, Resolutions Innovation Group. I am also now the interim chair for the brand new Wellbeing Committee. I am NC rep, so the liaison for the National Committee onto the YRES National Committee. But that's it for the moment with resolution.
Oh, awesome. That's it.
Just, keep me busy.
Yeah, we don't want you to get bored.
Family law.
I know. And you have recently set up your own practice as well.
I did in April, literally the Tuesday after the Easter weekend. I opened up MBS Family Law. I've been thinking about doing it for a while, but it was always like, oh, this is a really good idea. This is a good time to do it. And then I decided, yep, let's do this now. We've all learned how to work remotely and work from home, and it's totally doable. So let's do this. So it's been an interesting few months. A lot of fun.
So everything keeping you busy right now.
Yeah, exactly. And as the time progresses, I take on more. I'm also doing other committees and I'm doing other work, and it's just kind of like, yeah, keep me busy. I've just had a holiday where I've worked the entire holiday. So yeah, it's great.
I know you and me need to learn how to say no, but hey.
Yeah, exactly. It's a little bit sometimes.
Absolutely. So let's start to think about like people who might want to be getting divorced in England and Wales. So we're talking about the law in England and Wales because Scotland and Northern Ireland are a different situation. So specifically there, in order to get divorced in England and Wales, tell me what your position has to be jurisdiction wise.
I mean, I think a little bit before that is to think about the whole international stuff. It's not just divorce. Where do I start my divorce? It could be that you've divorced somewhere else and you also need to be doing something in here because of other reasons. So you might have an asset here or something. But if you were thinking, I need to be divorcing in England, first of all, sit down and think, why do you want to be doing this in England? Is it the right place to be doing it? Is it because you are living here full time? You and your partner or ex-spouse or whatever are actually living here full time. So that makes sense. Is it because one of you is here, but the other one is somewhere else? And again, that could work. So even if you're the one living abroad, but your spouse is here, you could still do that petition. Is it that neither of you are living here, but you're what's called domiciled? And that's a bit tricky, and you really need to have advice on that because domicile and resident have different meanings in England according to what you're trying to use them for. So is it for tax purposes? Is it for family law purposes? Is it for commercial law purposes? Is it for employment purposes? They all have a different meaning. But in family law, residence is where you're living. Domicile is where do you have a strong link with, effectively. So you could say, well, I was born in England to English parents who were living in England at the time of my birth, for example, and therefore I consider myself domiciled and I have family here that I'm very close to, and this is the language I speak, and this is where I have assets. And, if you can build that strong relationship with the country, then the odds are you are domiciled. But then that's quite flexible because you could say, well, I've been living in France for 5 years and actually, I'm a Francophile and I want nothing to do with England. I don't speak to my family and I have every intention of dying and being buried somewhere in the Loire Valley. And and you're not necessarily domiciled in England. So it's tricky, but that is also an option. So really it's, are you resident? Is your spouse resident, or are you domiciled? And then also with the residence, there are different kind of, how long have you been resident? Have you been here for like 6 months, but you're also domiciled? Or have you been here for 12 months? And all these little extra complications. But yeah, it's primarily where you're living and where do you consider yourself domiciled.
Okay. And why might you want to get divorced in England and Wales as opposed to somewhere else in Europe?
I mean, it used to be that England was the divorce capital of the world. And that's what you would hear in the press. Everywhere is talking about how this is the best place to divorce. You want to be doing it in London because it's just so much better, blah, blah, blah. I don't think that's true anymore. And I don't think it was true in the first place, but I don't think it's true anymore because of the way the laws have changed, and particularly with European stuff post-Brexit. You don't have that, the first person to start in the first country will have that country deal with their divorce sort of thing. It's not really how it works anymore. So you really need to think really carefully about where you're going to start divorce and why you want to do it there. Some people, it's because they have a link here, so their spouse is here or they're living here or whatever. Others, it's because they speak the language and they don't speak the language or understand the language of the country they're living in. So let's say they're in the Middle East, they might turn around and say, I don't speak the country, I don't understand the cultures. Others, it's because it would be really detrimental for them, let's say, to do it in that country because perhaps there are limited spousal rights, or perhaps they would share things in a very uneven fashion. For example, they might just choose, oh, this is the matrimonial regime, and therefore your spouse gets everything and you get nothing. Sometimes it's because the only place where there are assets is in this jurisdiction. There might be a property here or a pension fund. That might be the only thing or the biggest asset that they need to be dealing with. I find that with Europe, often what it is the idea of disclosure. Some countries don't do full financial disclosure as part of divorce. They will simply say, oh, what assets do you have? Please tell us. And if you say, I have nothing, they're like, oh, okay, this person's nothing. We're not separating anything. But when we do full financial disclosure, we have very detailed documents to complete. The court is really hot on finding out what there is and what people need to be able to move on with their lives, and how do you split things in a way that makes it equitable for everybody. And so that disclosure is important for some people because they're like, well, I don't know what there is. I'm the spouse that wasn't earning a living, was just at home, not just, but was at home raising the family, looking after the house, and I don't know what we have in savings or pensions. So sometimes that's an incentive as well. So there are multiple reasons. And then obviously, like I go back to the first one of divorce capital of the world, is because of the way we do things here, it's it always looks more generous, but it's not about being more generous. It's the fact that the court will look at so many factors because they're able to look at so many factors. A lot of civil law jurisdictions, like for example, France, they have very defined outcomes. You have a matrimonial regime that you have to follow. That's how you separate your assets. The Code Civil sets out very clearly how you're going to do a separation. In England, we look at everything. We look at, how long the parties were married and what the assets are and who contributes what and whether there are any dependents and what future income is going to be and what future needs are going to be and compensation. All these little things pop up, and the court will see what's relevant and what works and what doesn't work and what isn't necessary, and then come to a decision. So it often, for other jurisdictions, looks very favorable. But it's just a different, more thorough, I think, way of looking at separating assets. So yeah, sometimes there's also the idea of that person will get a better outcome if they do it here.
Okay. And so I know that for people who are like, there isn't really any question because they live here, they're domiciled here, all their stuff's here, they're going to get divorced here. They will divorce here and they'll separate their financial assets here. Are the people who do those things in different places? They might get divorced somewhere and then come and sort financial assets out here because that's where they are.
Yeah, definitely. Yes, basically. I I've come across loads of times where people will have gotten divorced somewhere else because that's where they were living, maybe, and or that's where they were living with their kids or whatever, or that's where their spouse started first, for example, pre-Brexit. And so decisions were made there, and then they come to the English courts and say, well, actually, we have a property here or a pension fund or assets that the first country that dealt with a divorce can't decide on, or wasn't able to decide on, or was unwilling to decide on. And therefore, I would like you now to look at these assets. So sometimes it's really just a straightforward of, you need to sell the property and split the assets. Or sometimes it's a bit more complicated because you're basically looking at, perhaps in the first jurisdiction, there wasn't spousal maintenance being proposed because that's just not an option there. So, and that person requires spousal maintenance. So maybe the court might, it's a big maybe, but maybe the court might say, okay, well, we need to look at that. Or usually it's going to be something like a pension fund. A lot of countries don't do pension shares. So if you have a really big pension fund here and you're like, well, actually, I'm entitled to a share of that, the court will then have to look at that. It might be that one of the family homes was here. And the court might say, well, hold on, this used to be the family home. This should have been dealt with. We need to split that up as well. So that might happen. So often it's kind of like a mop up. You've done it in one jurisdiction. They couldn't look at everything. You come and do it here. I touched on briefly about maintenance. I've had cases in the past where there was something going on in South Africa. The divorce was done in South Africa, but actually couldn't deal with the aspect of spousal maintenance. And we ended up going to the court here and saying, well, look, can we look at everything else and try to wrap in the spousal maintenance aspect. And that was something the court did as well. But you have to be really careful because although Part 3 of the Matrimonial Causes Act allows you to do financial remedies after an overseas divorce, there are certain hurdles and certain criteria that you have to address. And it's not always obvious, and it's not always just because you think you have a case that you will have one. So, there are certain things you have to make sure of. And, if you've got a pension fund here, then obviously the other country couldn't deal with it. Yeah, the court will definitely deal with that. But if you're asking for maintenance, the court might turn around and say, no, that's not applicable because that's already been dealt with by another jurisdiction. Or if you're asking to deal with certain assets, the court might say, well, no, because there's no reason to trigger us dealing with things because, for example, you might not have had primary residence here or whatever. So you really need to look at the rules and have a serious think about it. But it's always available as an option to think about. And what's really important to remember is it's not a cheap option. So it's not just, I'm going to file my Form A and that's it. You have to ask the court for permission to file the Form A. So you have to go to a judge and say, this is why I think you should be looking at this. And that in itself requires a hearing with a statement in support. And the court will have to look at it and say, yeah, this makes sense. Okay, now you can file your Form A. Okay, now let's start the full proceedings. So it's an extra hurdle. Okay.
Just for our listeners, what's a Form A?
Sorry. So the Form A is the name of the application form that you have to complete if you're asking a judge to make a decision on how to separate your finances.
Okay.
So there's a Form A and there's a Form A1, and they deal with different aspects of what's financial remedies. So how do you separate your assets? And depending on what you're looking for, you would file that form.
Okay. So,
yeah, it's a shorthand.
So you've got, let's say, you've got assets in France, for example, you've separated certain assets that you hold in France, then you're coming to England and saying, can you just deal with these ones that haven't been dealt with over there? Is that basically what we're doing?
So basically what you have to do is you have to wait for the proceedings in France to be totally finished. There has to be no room for appeal. Right. So you have to have gone through the entire process.
Yeah.
And when you've got to the final decision and the court can make no further decision on any asset,
yeah,
then you can come to England and say to a court, these are the assets that are in England. The French court was unwilling to deal with this. Please, can you make a decision? So I had a case once where there was a French divorce. It was ongoing for years because French divorces last 4 years because you can appeal everything for any reason whatsoever, which is not what we do. It doesn't work in our jurisdiction.
Brilliant.
But after many years, the the French courts have been unable to deal with an English property. And in the process of the French divorce, the husband had sold the English property, transferred it into cash, and then just had it sitting in the bank, spent some, transferred some over into other countries, obviously not France, because then it would have become an asset that the French court made a decision on. And so the wife came to the English courts and said, I've had this divorce in France, could touch nothing of the English assets. This is what's happened to property. Can you look at this? And the court said, yeah, of course, we're going to look at this. So they then started the equivalent of full-blown financial remedies. So how do you separate your assets? To look at that specific amount of money and to make a decision on what will be a fair split of that, bearing in mind what had happened in France. And because the wife had come out very badly of the French proceedings because of the matrimonial regimes and how those were not in her favor, she got a larger share of what was in England to create a more equitable split in the eyes of the English court, which is not what a French court would have done, but it's how the English court viewed it. So it's kind of the mentality, the thinking behind it was she didn't get any maintenance, she didn't get enough to rehouse herself, and let's give her a bigger share to make sure that she's protected, sort of thing, which isn't how the French would do it, but it's how we look at things.
Okay, it's very complicated, isn't it?
Yeah, and it's not, you have to be really careful how you're running your case in that other country, if that's what you have at the back of your mind, because doing certain things might create a negative knock-on effect in England, for example. The court might say, well, actually, that's been addressed, therefore we're not touching it. Even if it wasn't a favorable outcome, we're not looking at that. So, yeah, it's complicated. Also, it's quite expensive, as all court proceedings are. So a lot of people don't necessarily want to do that because they've spent a fortune in one country. Why would they want to do it in another? But I think for things like pension sharing, it's really important that you look at that because pensions are often overlooked in this jurisdiction anyway. So if you're also looking at coming from another country, it's a shame because it's an important asset.
Yeah, absolutely. If I can't think what I was going to ask you something then that came into my head while we were talking about what was it about? I'm sure it'll come back to me in a minute.
No problem.
It's gonna be one of those days. What about if you've got if you're having a normal divorce in an English court, so divorce being done in an English court, finances being considered in an English court, but you've got overseas assets. How are those viewed? So say there's a property in, let's stick with France. So there's property in France, for example, or a pension held in another jurisdiction. How are they considered by the English court?
So normally what the English court does is they want advice from that jurisdiction to usually find out how that jurisdiction would separate the assets. And also what would that jurisdiction do with an English order? Could they uphold an English order? Right. So it's not that the English court is going to apply French law, but it's like they want to know what will be the likely outcome in France. They would want to know, would the French be able to do the equivalent of a Part 3? So would they be able to say, oh, you've had an English divorce, now let's look at the French assets separately. And then they'd want to know things like, how do you enforce an English order? Would it be respected? Do you have to apply to the French courts for that English order to then be turned into a French order, to then be upheld by the French courts, things like that. So they'll want to have all that evidence just to make sure they understand how it works. And they may very well make a decision on all those assets. So it's a little bit weird in France at the moment because I think like a lot of Europeans, they're kind of annoyed with the Brits for Brexit. And I've had some courts say, of course, we'll uphold an English order. Of course, why wouldn't we? And then I've had other courts in other parts of the country say, are you kidding me? You chose to walk out of the EU. We're not going to. And it's really petty, but so I've had like Parisian courts say, yes, of course, we're going to enforce this in the same way that Parisian courts will enforce orders from the States. I've had orders in south of France where the judge says, whatever, That's your decision, it's not ours. So it's, and then of course they appeal it and it goes up to a higher judge, and the higher judge will eventually find in favor of the way things should be, but it's complicated and it's expensive. So it's really tricky. You need to be really careful about that. And that's why the English courts want to know what the position is. So I'm finding at the moment that, so prior to Brexit, when we were all in the EU, the way petitions would work is whoever's got their petition up and running first,
yeah,
that country would make all the decisions on divorce and on finances. And the other country would accept it because it's what was first in time, so be it. Post-Brexit, we don't have that anymore. So in the EU, much like the rest of the world, it's no longer about who's first in time. Some courts may turn around and say, well, look, we'll let England sort it out because they were first, and then we'll see what happens. But the majority are very much thinking of, no, you've started a legal petition in this country, we're going to run it as well. So you have a lot of concurrent divorces running at the same time in parallel. And then it becomes a matter of the countries deciding who should be doing it according to where the assets are. So if you've started, perhaps, I'll give you an example, you might have started in England first, and then somebody starts in France, and the French courts might turn around and say, yeah, we could suspend it and wait and see what goes on in England, but actually we're just going to let it run because, you know, you're English and we don't like you. And you think I'm joking, but we don't like you. So the English courts will then turn around and say, well, hold on a moment, should we be doing it here? Because do we have enough assets? Is there a reason for the English courts to be making a decision? And if we make a decision here, will the French uphold it? So in some cases, the English courts are turning around saying, no, there aren't enough assets here, or there are no assets here whatsoever, even though you might live here, everything's in France. So we're going to shunt it over to the French court to decide because that makes sense. And because we know that if we make an order, the judge might overturn it. So what's the point? So it's difficult.
Yeah.
But saying that, if you go further afield, for example, if you're looking at certain countries in the Middle East, the English courts might say, well, look, no, obviously it's fair that we make the decisions here because they might not be able to deal with those assets in that jurisdiction, or it might be unfavorable to one person, or actually those jurisdictions would enforce the laws of the country where you were married in any event. So if you were married in England, they're going to do that anyway, so you might as well just do it here. It really depends.
Okay. I've remembered what I was going to ask you.
Oh, go on.
So we talked before about filling in the Form A or Form A1.
Mm-hmm.
Is it still an option to use like mediation or collaborative, or do you have to go to court in the kind of, in that sense of the word, to get the decision made by the judge if we're looking at non-UK assets?
So the forms still have that section which asks you, have you gone to a mediator? Have you tried mediating?
Okay.
And it asks you for exemptions. You know, if you haven't, so if you have gone, the mediator has to sign off on the document. Sure. They sign off and they explain why you are where you are. You know, either you did a MIAM or it's not appropriate or whatever. But there are exemptions. It's like 4 pages of exemptions. And one of those exemptions is you don't live anywhere near each other, or you don't live anywhere near a mediator. I mean, I think that should probably be changing because now we do everything online. So it doesn't really matter if you're not living next to anyone, but that is one of the exemptions. Another exemption is, I think there's one which is risk of harm or risk of, I think one of them is risk of harm. So there is that as well. If you're saying, well, look, it's a danger, but the most common one for international is we don't live anywhere near each other. We're nowhere near a mediator. Can you please start this?
Okay.
The other aspect is you could self-certify and say this is not appropriate. At the front, you could say, I know I don't have to go and do this because X, Y, and Z. And the court may choose to completely ignore the fact that you haven't gone for a MIAM or you haven't gone to mediation. So for most international cases, you kind of fudge the whole mediation aspect because it's a matter of urgency, because you know that mediation isn't necessarily going to be easy if people are in separate jurisdictions and there are timing issues. You know, if they're in France, yeah, it's fine, you can do it, it's an hour's difference. But if you're in Singapore, for example, and the one's in England, having the right timing so you can have that, you know, it's going to be difficult. So, and there's also the fact that you probably will need an order if it's an international case. You're going to need something relatively concrete which sets out the situation. And although you can reach an agreement and have it recorded in a consent order, so you reach the agreement, you have a solicitor draw it up as a consent order, and a judge stamps it, and it's valid because it's a judgment. Some people would just rather start the court proceedings anyway and see what happens.
Okay. So
I'm not advocating that. I think mediation is great, but I'm finding, unfortunately, a lot of the time in my practice, you end up in court.
Yeah. So mediation is still an option. You can still have non-court settlements,
of course,
consent order drawn up, but in most cases, because of the complexities, it's probably not going to be a thing. Okay.
And you often have contested jurisdiction cases where somebody is saying, oh no, yours is the wrong jurisdiction, mine is the right one. So then you're in court anyway. You're arguing about the divorce, but it has a knock-on effect on the finances.
Oh, wow. It's very complicated, this, isn't it? What about children in terms of international? I don't know if this is your area of speciality, so I may be asking you about something that
No, it's half of my practice is children stuff. I think that actually children is a bit easier on that front because most of the time it's the jurisdiction of where the children reside that makes the decision.
Okay.
And it's all because of things like the Hague Convention and stuff like that. So, you know, if you're in the EU, when we were all in the EU together, Brussels II was very clear that it was a jurisdiction of where the child resides. So, you know, if you were doing your divorce and your finances in France, but the kids happen to be residing in Paris, then it would be the French courts that would have to decide about the children. Now it's usually the Hague Convention that steps in. Not all countries, but a lot of the ones I deal with.
Right, so you need to explain the Hague Convention.
Okay, so there are some international conventions and regulations that govern certain aspects of family law. So when we were in the EU, we had Brussels II, which was one of the big conventions that dealt with everything to do with family law, amongst other things, but everything to do with family law if you were in the EU. Another one is the Hague Convention, so a convention that was drawn up based in The Hague. And there's quite a few of them, so you need to make sure you're looking at the right one. And several countries have signed up to that. And in particular, you need to be looking at the ones that are dealing with the children, because there's a whole bunch of them and they deal with all aspects of Hague Conventions, aspects of lots of things, but the ones that deal with the kids. And some countries are signed up, some are not, but the ones that have signed up basically say, we agree to these sorts of things when it comes to children. So it might be protecting them from, you know, kidnapping or abduction, or, you know, which country has the right jurisdiction to make decisions on them. And it can talk about child rights and all this. So it's a whole bunch of stuff effectively dealing with the children. I'm simply really grossly oversimplifying things here because
that's fine. Grossly oversimplifying is good for the time being.
But it's basically a set of rules that those countries sign up to, but not all countries sign up to them. And some sign up to certain Hague Conventions and others sign up to other Hague Conventions that say different things. So you really need to be careful about which country you're going to, what they've signed up for. So most EU countries are signed up to the same thing, and we're all agreed that if the kid lives in that country, then that country is going to be the one making the decision. So if your child is based in Italy, then Italy's going to make a decision regardless of where the child was born, where they were living beforehand, etc. Some countries, it's a bit murkier. So, for example, the Middle East doesn't necessarily have the same sort of sign up as we do, and you could argue that although the children are living in that country, you're asking an English court to be making decisions. So you could start your divorce and your finances in England and tag on to that a decision being made on the children because of the fact they're in a country where it's not signed up to things and the law would not work in the favor of the child, basically.
Okay.
So it's really important. And I think you really think about that for countries like anything in the Middle East, but also if you're looking at countries perhaps further afield. So I've had issues where I've had clients with kids in Vietnam or in Thailand, because that changes also what you can do and how to protect the kids. And then you also have weird and wonderful things like the states, where each individual state has its own different little way of looking at things. And so yes, have a careful think when you're looking at which country is best to deal with the children. What's happening in that country? What are they signed up to? Are we signed up to the same things? Most Western countries, I'd say, it's the wrong term, but most of the countries I've dealt with are usually signed up to the same thing. So it's easier to argue. Look, this child is residing here. This is where it's going to be. The other thing you have to think about is how long does that child have to be in that country before that country can make a decision? So, if you've been there for perhaps a month, that might not be enough. Perhaps 3 months might be enough, perhaps 6 months. It would depend on whether they have moved there, they're settled there, they're going to school. It could be whether they were on holiday there and they've simply been held back, or there's a whole bunch of facts to look at as well. So it's not straightforward of, oh yeah, I went to France and I kept my kid there and therefore France is deciding. Even if you were there for 6 months, the court might say, well, no, England still has jurisdiction.
It's so complicated.
Also, something to think about, because if you, for example, France, I had a case recently where child was based in England, mum went back to France without father's approval. Well, she thought she had father's approval, she clearly didn't. She went back to France, and father immediately issued an application in the English court saying the child had been abducted and the child had been returned under the Hague Convention. And it took us 6 months to get an order in France for mum to be asked to return the child to England. So despite the fact that the child has been living a huge amount of time for a very young child, out in another jurisdiction, going to school, living, speaking a different language, the jurisdiction to make the decision was still this one.
Okay. So if we've got assets in another country, if we live in another country, but we've got assets in the UK, if the kids live in another country, all of these complexities, we basically need somebody who knows all about this stuff to speak to. So a family lawyer who has experience of international work is going to be pretty essential, because it sounds mega complicated. Have I got that right?
I think if you've got anything with an international aspect, whether you are an international person, whether you have assets in another country, whether you entered into a prenuptial agreement in another country, whether you have kids here and one of you is living abroad, whether you are looking at having a maintenance order made in one country enforced in another, whether all these sorts of things. If you've got an order, I often have people who have orders in other countries, whether it comes to the care of the children, separation of finances, child maintenance, or whatever, who then end up living here. You probably need to speak to someone who has some understanding of international law. International law is not technically a thing for family law. We don't have like an international law topic, but someone who is used to dealing with the international complexities, if only so that they can say, flag this up, this is a problem, or you need to be speaking to someone else about this.
Yeah.
We don't want us to be treating it like it's a normal everyday thing, because it might, yes, the law will be the same in England, but actually you have to think about those other complexities in that jurisdiction. And what's often is what I say to my clients is have a chat with a lawyer in that country as well. Yeah. Definitely have a chat in both. If you've got two countries, have a chat with someone in both countries so you understand what's going on in both. And they'll each flag up their own worries, and then you can always have them speak to each other if you prefer, but at least you understand what's going on.
Okay. I feel like my head is utterly mashed now. We are, believe it or not, pretty much at the end of our time together. That's absolutely flown, I think, probably because they were so complicated. But I have a feeling that some of our clients and some of the people listening may be interested in having a chat with you if they've got any of these complexities going on. So how can they get hold of you?
Email. So Melanie at mbsfamilylaw.com. Have Twitter handle M_Bataillard, BATAILLARD. Those are the two obvious ones. And
Fantastic.
Instagram, but I mean, I wouldn't say anybody to contact me through Instagram because it's just post photos of me eating stuff, so it's just not going to work, really.
You post lovely pictures of the beautiful places that you're staying in.
That's true. That's true. There was a few photos of beaches and swimming pools recently. Yes,
Big yachts and things.
yes, that made me feel better.
Me too. We'll put the links in the show notes anyway. It just remains for me to say thank you so much for joining us today. That was really useful, even though my brain now feels fried.
Tamsin, that was great. I'm so used to doing the interviewing and podcasts. I was really nervous about being the interviewee, and I absolutely loved it. So thank you,
Excellent. Jolly good. Thank you for joining me, and I hope you all
Tamsin.
enjoyed it. See you soon.